para nada. Que se los traigan a la gente, ¿no?
Okay. So, empieza, José.
Good morning, everyone. Again, this is the Mexico City Investment Arbitration Days within the context of World Arbitration. Within the
Better? Good. So again, welcome everyone. This is Mexico City Investment Arbitration Days within the context of WOW, World Arbitration Update in the Americas. And I have the privilege of giving a few words about WOW, our two objectives as founded 3 years ago with my co-founder Ian Laird and many others. We have a twofold objective, one which is updating on issues of investment arbitration, international commercial arbitration, and public international law. Updating whom? The whole arbitration community, basically the whole globe, in the Americas, in Asia, in Africa, in Europe, in Oceania, etc. And also the other objectives, decentralizing international arbitration, because we know that there are incredible counsel, arbitrators, practitioners, academics, not only in the main centers of the world, but beyond that, in the Americas, in Mexico, in Bolivia, etc., in Europe, not only in the main cities of Europe, in Asia, Africa, etc. So those are the two objectives, and we are very privileged to be partnering with Mexico City Investment Arbitration Days, and very thankful to all the supporters and leaders of this seminar, especially Ricardo Ramirez, Hugo Romero, and their colleagues, and also our colleagues from Van Bell and Bellis. And for now, I would like to say that this is going to be an incredible panel. I have a little bit of a heart for this panel because I began international economic law in my PhD with a focus on WTO law. So the panel here is on what has ISDS to learn from WTO law. And before giving the floor to our moderator to do some justice, I should introduce her. Our incredible moderator is Samantha Ataide Arellano. Samantha is a partner at RRH Consultores practice, and she practices here in Ciudad de Mexico. She specializes in international trade and investment, regional trade agreements, and investment protection, intellectual property, and customs. Samantha has acted as lead lawyer for numerous international trade and investment agreement negotiations and implementation processes, including USMCA, CPTPP, and the modernized EU-Mexico trade agreement. She was a representative of the government of Mexico in trade and investment disputes under the WTO, NAFTA, ICSID, and UNCITRAL. Also as legal advisor for the negotiations and implementation of international trade and investment agreements, including the TPP, the Pacific Alliance, and the modernization of the Mexico, Brazil, and Mexico-Argentina trade agreements. She was also legal counsel for WTO disputes. And now I yield the floor to Samantha.
Thank you, Jose Antonio. First of all, I would like to welcome everybody to this second session of our today's agenda on what can ISDS and ISDS lawyers learn from WTO and WTO lawyers. So I'm sure you will find this session interesting, given the times that both the WTO and the ISDS systems are facing. Today, our panelists will be discussing two initiatives, two multilateral initiatives. One that is happening at the UNCITRAL in Group 3. This is the Multilateral Investment Court. And the other one that is happening at the WTO, which is the Investment Facilitation for Development. So as both systems are currently facing challenges, or if not crisis, our panelists will be addressing the overlaps between the systems and also what could be drawn from the WTO systems to improve or to correct the current flaws or the perceived flaws of the ISDS system. As we know, both systems come from different judicial background. They were designed to achieve different objectives and they have their own way to resolve disputes. Yet, the two systems are based in public international law and international economic law. So our panelists will be discussing also the substantive and procedural synergies that both systems has. And in addition, they will be touching upon this new initiative in the WTO, the Investment Facilitation for Development. Before we begin, let me introduce our distinguished panelists. They told me to keep that short, so what I'm going to read is the shortest I could get. They are very modest. So I will start in the order that they will be speaking. I have Ricardo Ramirez. Ricardo Ramirez has 25 years of experience gained in more than 70 international disputes under different trade and investment agreements, either as counsel, arbitrator, or member of the WTO appellate body. In 2009, he was appointed as member of the appellate body, where he served for 9 years in 20 disputes. Ricardo is one of Mexico's leading arbitrators, having acted in a numerous investment disputes. He is a member of the panel of arbitrators of ICSID, the Beijing Arbitration Commission, the Session Court of International Arbitration. He is also part of the panelist roster of the USMCA, the EU agreements, as well as trade agreements between Mercosur and Colombia, Ecuador and Venezuela, Mercosur and Bolivia, and Costa Rica and Chile. He was also appointed as independent expert of APEC. From 2006 to 2009, he was head of the international trade practice for Latin America at Chatburn and Park. Prior to that, Ricardo was Deputy General Counsel for International Trade at the Ministry of Economy, where he provided advice on trade and competition and policy matters, and represented Mexico in several disputes before the WTO. I welcome Ricardo. I have also Philippe Debert. Philippe joined Van Bellen Bellis in 1988, and he's currently the managing partner. Prior to joining the firm, he worked as a research fellow on the international trade law at the University of Leuven. He focuses on EU and WTO trade law, as well as EU custom law and export controls. He has been involved in most major EU anti-dumping, anti-circumvention, and anti-subsidy proceedings since 1990. He has represented clients before the European Commission, the EU General Court, the EU Court of Justice, WTO panels, and the appellate body. In the area of free trade agreements, he has advised sovereign clients during the negotiations with the EU and on the implications of Brexit. He has assisted WTO members in various WTO disputes. He has also represented several large manufacturers in high technology products in disputes concerning customs classification, valuation, and origin. Finally, last but not least, I have Carlos Bejar. Carlos Bejar is a domestic and international trade attorney in Holland and Knight, Mexico's office. He counsels companies on international trade strategies, investment, government procurement, regulatory compliance, unfair trade practices, intellectual property, and customs procedures. He also advises on commercial, private, and international trade disputes. He was appointed as member of the panelist roster of the USMCA Dispute Settlement Chapter and Mexico's roster for the disputes concerning unfair trade practices. He previously served at the Ministry of Economy of Mexico as General Counsel for International Trade for more than 6 years. At the ministry, he was responsible for coordinating Mexico's participation in trade and investment disputes, as well as providing legal advice on international trade negotiations and foreign trade matters under the WTO regulations, the NAFTA, the TPP, and other free trade and bilateral investment agreements. He also served as an economic counselor to the permanent mission of Mexico before the WTO in Geneva. He has nearly 20 years of experience working in the Mexican government on trade and foreign investment matters, including arbitration. Thank you, Ricardo, Felipe, and Carlos, for joining us today. In terms of our organization of the session, each of our panelists will be presenting and addressing a set of topics and following by a round of comments or reactions by the others. So with these introductions, I will turn to Ricardo. Ricardo, when we talk about the challenges that ISDS system and the WTO systems are facing, there is one particular topic at the core of the discussions between states. This is the appeal instance. Probably the initial question for our session will be whether the WTO appellate body could serve as a model for an investment court.
Everyone, I'm going to try to be provocative and say controversial things, so Philippe can correct me, and Carlos as well. And of course, you have to start with the basics, which is what is the WTO dispute settlement system for those that are not familiar, or trade geeks like some of us here. It's a three-tier system, or it used to be at least a three-tier system, where you had consultations, and you have other two instances, and in the words of George Abisab, one of them was of an arbitral nature, which is the panel stage, and the other was of a jurisdictional nature, which was the appellate body. The appellate body was, because it's no longer functioning, used to be a 7 members standard body who used to adjudicate, and I will go to the standard and talk about some of the things. To talk about whether you can transpose the WTO appellate body to investment system, I will start to talk about the strengths, and maybe that strengths could be mirrored or could be taken by an investment court, and I see a lot of problems with that, but I will start with some of the basics. What would be the good thing about the appellate body, or brought the appellate body to adjudication, and whether that could be translated into investment. The first one will be how the appellate body was constituted. The appellate body was constituted by 7 individuals. I'm trying to recall the exact language of the WTO treaty, but it says something like it has to be they have to be geographically representative of the WTO membership. So, and there were 7 members, and there always have been a discussion, at least for some. Basically, the Europeans always take one place. The Americans will take second place. The Chinese will say they have 1. The Latins will say they have 1, although Canadians always objected to that because they were, where do you put the Canadians? And you had Asia and you had Africa as well represented. And immediately jumping into investment, good luck in setting how many members of an investment court you want, and good luck in selecting which country will get them, and good luck if there was a problem, because you will have, of course, private companies wanted to have a say in who will be composed, how this investment court will be composed. So good luck on that. The second issue that comes in the appellate body, and I think this is one of the, once you have the 7 individuals, first there was a discussion on diversity. When I entered into the appellate body, we were 3 and 4. And had Jennifer Hillman not been asked not to be reappointed, we would have had a majority of women in the appellate body at some point. The other thing is professionalism. Not all appellate body members were lawyers. There were 1 economist, 1 political scientist. And at the end, thinking about the discussion we had yesterday about damages, and one of the things that I had when that presentation was, some of us that have adjudicated this dispute, you have very good damages experts on both sides. And you are a lawyer, you cannot change that. And sometimes you will need some, I mean, they are experts. You're trying to understand what they say, and they are very articulated. They are very convincing. So what do you do when you are trying to adjudicate a dispute where you have very good damages experts on both sides? So you may want to think when you're thinking about an investment court, whether you need really not all to be lawyers, and you need some economists there that will give you some feedback. And I can tell you, having, and I'm thinking right from the bat, Ujjal Bhatia, persons like Ujjal Bhatia, a great economist and a great politician, brought a lot into the discussion. And I think that was one of the great strengths of the appellate body. So the other thing is of course, one of the features of the appellate body was coherence. But there are 2 things, and we discussed this yesterday. You have a 500 pages or more than 500 pages cover agreements that cover services, goods, intellectual property, but there was the same body of law. So there was room for coherence. Dissents were not very proper. And actually, I always try to say this when I am in a tribunal investment, that I come from a school of thought that believes in collegiality and believes in trying to reach agreements. And that's what one of the things that we had in the appellate body, which is there were few dissents. Many will say that's not good, and I have to be fair on that. But at the end, it brought coherence in the WTO jurisprudence. And it got to a point where the lawyers will not discuss the substance of the law, but rather what did we mean in one decision or another. So it came to that point, that consolidation of the jurisprudence. So, and that will be a problem in bringing that to investment. And that ties to the other point, which is the standard that we had. Our standard was only look at the law. We were supposed to look only, we were a court de cassation. We will only be able to look at how the law was interpreted by the first instance. And we could not look at the facts. We could not look at the facts. We were not able to look at the facts, but there was some window to look at the facts. And maybe Philippe wants to talk about this. There was a window that when we ever used it, there was very controversial. Whether we were looking at facts, we were stepping into the shoes of a panel, blah, blah, blah. So at the end, and when I look at what is in the working group 3 drafts, you're looking at a mix on a standard of annulment, which is a very different standard than the standard used by the appellate body. But you also look at standard like the appellate body and said, well, when I look at it, I said one or the other, or you want another standard for an investment court. So the first thing you have to figure out is what will be the standard? What will be the standard of review of that investment court? And whether you want to translate that, the appellate body, which will be a very expansive standard, and the appellate body is in demise, partly because of the standard, partly because the standard, some countries thought, the US, that that standard was very expansive. And we really went overboard, to say the least. I will timing, and I think that's another lesson that the investment court may want, and maybe investment tribunals also adhere. The appellate body had a 90-day deadline to issue a ruling, and that 90-day deadline was for a lot of years follow, I will say, mandatorily. And when I got into the appellate body, whenever you file an appellate body case, there were already a schedule that would put, and it was, to be frank, it was not 90 days, it was 75 days, because you had to issue a ruling in the 75 days so that it will allow for translation into French and Spanish. So you have a 75 court. In the recent cases, in the last cases, we went beyond that 90 day. And we were accused for that. There were complaints about we will miss the 90 days, no matter what. An investment tribunal could take 4 years to issue a decision. We didn't follow the 90 days. And even in cases very complex, such as, for example, the Airbus disputes or the Boeing disputes, we didn't take that much, talking about 6 months, 7 months, 8 months, 9 months to issue a ruling. So that's something that you may want to think about when you're thinking about investment. Investment in impartiality and code of conduct, if I would say. And that's something also you want to maybe take some lessons from the appellate body. Maybe we were very extremist in the appellate body. I always tell this anecdote. When I got into the appellate body, they will ask me what would be my preference of coffee, whether I would want the coffee, cappuccino, whatever, because there will be someone that will take that coffee to our chambers. Because they did, back in the old days, the first generation of appellate body members did not want appellate body members to mix with the membership in the cafeteria. That was all because I managed to, we bought a coffee machine. That was the way it was resolved. But at the end, it tells you something about, for 9 years, I didn't have lunch or breakfast with the Mexican ambassador. And the Mexican ambassador was my former boss, was my friend. And I couldn't have lunch with him or dinner or whatever. So, and we took that by heart. And I think that was important in following the code of conduct. It was surprising to see, I mean, and it's in a different, it was a different school of thought. Of course, appellate body members were not able to do any trade remedies or things at home, and we were very and at the end it was very well understood between the appellate body members how the code of conduct should be followed. So and that is another thing that you may want to reflect on, this impartiality lessons on the appellate body, because I think that's a model that you want to use. And I may say that the demise of the appellate body was maybe because we were too impartial or too independent. And I will leave it at that. I told you I was going to be controversial. So I will leave with those. So I will leave you with those thoughts. I'm not talking about the bad things. I'm not talking about the non-benefits. I forgot. Sorry. There was a different secretariat in the appellate body, and you will have 100 lawyers working for the 3 divisions that handle dispute settlement: the rules, the legal, and the appellate body division. So you have 100 lawyers thinking 24/7 about trade law and about trade agreements, and that will help a lot will help a lot for us when we were adjudicating, and even panels and the appellate body helps the adjudication because, and there were very, very high quality lawyers working in the secretary, at the secretary, but I will leave it at that. Sorry, Flip.
Happy to say that I disagree with a lot what you just said, but I would like to start really from the notion that both regimes are very different. I think yesterday we talked about the objectives of investor-state dispute settlement, and we talked about the specific nature of regulating trade investment. And in fact, I was very much reminded of the origins of the GATT and the WTO, which were also actually aimed at making trade law and trade disputes boring and technical, to remove it from the political sphere, so that we do no longer have the British warships bombarding Buenos Aires to obtain payment of the outstanding loans, but that basically it became a matter of lawyers, and preferably the most technical and boring people around. So we managed to do that actually, and we were very much concerned in that aspect of respecting a multilateral rule-based trading system in the same way that I think nowadays when we talk about the discussions ongoing on ISDS, because the alternative is power play, is power-based decision-making. And I was reminded of that also in the panel this morning when I heard about these 5 privileged sectors in the USMCA. Obviously, this, in my view, reflects different balances of power in the negotiation process. So we had these objectives, and basically these objectives also tried to achieve what was also mentioned yesterday, very much about what is important for trade and investment. And that was clearly predictability and certainty of the environment. And I think both systems are actually aimed at ensuring that there is predictability and certainty in trade and investment. To go now to the factors which led to the establishment of the appellate body and its recurrent systems, I very much share what Ricardo was saying as the different issues involved, but I don't think they are the real reasons for the demise of the appellate body. And again, referring to what was said yesterday, to a large extent, we are confronted with sovereign states which do no longer want to be governed by multilateral rules. Whether it's in the WTO or whether it's in investor-state dispute settlement, there is this backlash of seeing this kind of organizations and rule systems as actually an infringement of national sovereignty, which limits the freedom of states to regulate. Now, what were the issues mentioned by Ricardo on explaining why the appellate body didn't work? First of all, facts, but Article 11, which permitted in certain exceptional cases to look at the facts of a dispute in the appeal process, I think actually was not used that often. And it was used mainly indeed where we had very incongruous decisions by the panel. It was mainly seen as a kind of corrective mechanism rather than a de novo review of the facts. Coherence, and I think this is a very important issue. Why the problem of coherence in copying the system of the appellate body to the ISDS system is that you have to be very careful that if you have 100 lawyers in a secretariat, you will, and the requirement of coherence and predictability and certainty. That's what we're talking about. So predictability and certainty requires a certain form of coherence, but you put that together with 100 lawyers, and before you know it, you have a completely developed judicial system. Which becomes rather inflexible, especially in the context of the WTO, and I will briefly talk about that a bit later. We had the deadlines. Obviously, I think this is an issue, deadlines, and the sheer amount of paper that is being produced in the process. I think these are issues that can be addressed and have been addressed now in for instance, the ad hoc arbitrations or the multi-party interim agreement. But I think problem and accusation which was leveled by the US mainly against the appellate body was judicial activism. Judicial activism basically consisting is you develop through your judicial system, through the coherence, a kind of new legal system, which in a certain sense departs from what we have negotiated at the time, where it goes beyond what the members had agreed on. That is certain sense judicial activism. But in my view, judicial activism has always been necessary because we were dealing with a set of rules which has been negotiated in the 1940s and in the early 1990s and haven't been changed at all. So we were confronted with new challenges on environment, on national security, and you have to deal it with these old tools. So in a certain sense, judicial activism was, I think, the necessary consequence of the inability of the WTO to legislate. Now, that means that, in my view, if you would have a system similar to the appellate body, if you would have a two-tier system in dispute settlement, in investor-state dispute settlement, and you would have an appeal mechanism. It is very, very important that you have a corrective mechanism in there, which is it by interpretive rules or by renegotiation of bilateral investment treaties that gives the parties the flexibility to correct, let's say, the excesses of judicial activism or of the excesses of coherence. But in my view, many of the objections which have been leveled against the WTO appellate body are actually not the main issues. I think the main issue has been the fact that the system had become too inflexible, created paralysis in coping with new challenges, and that was not the result of the people in the appellate body. It was mostly the result of the complete inability of the WTO membership to adopt and to negotiate rules and to adapt also interpretive declarations of, for instance, correcting a number of things. So I don't know anything about investor-state dispute settlement, but if you want to have my advice, if you go in that way of creating a court, make sure that there is the possibility to correct by the members or by the parties, the participants, to correct for the future certain interpretations that may have been adopted by this permanent court of appeal. So, thank you.
Philip. Carlos, what could you say about what are the lessons that the WTO dispute settlement system, in particular, the appeal stage, could provide or could not provide to the ISDS system?
Thank you for having me sitting here next to Samantha, Ricardo, and Philippe. It's an honor to be here, and it's quite an interesting topic. I think we can be more open as to the concepts of the relationship between the WTO and investor state in terms of the architecture of the systems, because they have both been subject to severe criticism. I mean, the situation of the appellate body today is really to us, or those of us that started our careers doing both investment and trade, it's I would say a pity, because we created, or we were participants in the creation, establishment, and development of that system, and seeing it not working as it was predicted or as people envisioned is quite shameful. I don't know if there's really a crossover exercise. I think it's more about how these mechanisms are created, what is the future of these mechanisms, and I think that's where we have to place our attention, because NAFTA was very creative in having a lot of mechanisms that were new for free trade agreements. They had an investment chapter, a state-to-state chapter, environmental disputes, labor disputes. They have a 707 committee for addressing disputes in agriculture. So it was quite an interesting group of mechanisms that I think we have now only fixed our minds in one type of dispute settlement mechanism, and I think that's where we have to be creative. And I welcome the European activism in saying maybe we need this appellate body or this group of judges that will review the awards, because it creates discussions of topics that are necessary to be discussed in order to make the systems effective and not be in the same place where the WTO is right now. Because we don't know if tomorrow another developing country that is on the top 10 of most sued countries or with more investment cases is going to drop out of the system. So that's something that is not good for, I think, investors that really only have this mechanism as a true possibility for adjudicating a dispute that could help them recover the damages. But what I get from Ricardo is the first thing is that it is very convenient to have a cafeteria for appellate body members or for judges in the ICSID, and that's one of them. The other thing is that it's important to have a code of conduct, because when I was in the WTO, I stopped working with or talking with Ricardo for almost 8 years. We can only say hi and goodbye because of the tuna dispute. And I think that it will be very interesting to share with you, or those of us that negotiated free trade agreements. I know Meg did, I know Hugo did, and some of the lawyers here that have direct experience in both commercial arbitration and private and investment disputes, on how one can take the lessons from one architecture of dispute settlement to improve the other dispute settlement proceeding, and not only address these, I think, unfair political criticisms that have really will not result in solving the political concerns of these mechanisms, which I think that's where we are. Even though we had amendments to the ISDS rules under UNCITRAL and in the ICSID, I think those political concerns are still there. They address this, what they could do to get out of the discussions, many topics that were thought as this is where the evil lies, but at the end it was like, no, that's really not the truth. There is something else there. There is some concern about a government being told what is and what is not correct. And governments like Canada and the US dropping out of the USMCA, having no dispute settlement for investment disputes, is a worry, a signal of worry. And I think that we should think about, and this is probably a question for Ricardo, he can address it later, if there should be some sort of, at least, damages, that's what you were suggesting, some sort of damages appellate body for the investment disputes, and also the role, and these discussions were happening as well a long time ago, having like an advisory center similar to that of the WTO for investment disputes, which is something that could be positive and maybe would be a better alternative than an appellate body for investment disputes.
I was going to provoke Ricardo a little bit further, because we were discussing about the viability to have some sort of appellate body approach in these discussions within the UNCITRAL, but also what about other WTO tools? I mean, after the WTO crisis, those friends of the system got right away creative, that some of them joined the multi-party agreement, but others in an ad hoc basis are resorting to the 21-5 appeal mechanism, arbitration mechanism. So could this be something that for those states that are concerned and are the proponents of the UNCITRAL reform of the ISD system be an option, at least to address certain concerns, or at least to have it in mind as a tool in case that the discussion don't go the way they want in that framework?
I think it goes, and I believe Philippe was implying this, which is the great feature, or the only feature that distinguishes, or the main feature that distinguishes the appellate body from any other court, any other court is compulsory jurisdiction. It's the only court where the United States cannot refuse to adjudicate. And that is a problem. And that created a problem. And that is part of the reason why we are where we are. So at the end, that to me is the first fundamental questions we have to solve. Will you do an appellate system only for the ones that want to adhere to that? Or will you go for the full Monty? But the full Monty will require a lot. And I don't think the US will repeat the exercise in accepting compulsory jurisdiction of an investment court. If you can jump that hurdle, that would be to me that would be the first one. And if you don't do that, then you end up with initiatives. And you said, for example, the MPIA, which is the initiative that was taken in the WTO as a way to try some countries, adhere, Mexico among others, said, okay, let's create a mirror appellate body, but a very limited appellate body. And even there, and I would say that, and even there, the first decision that came out, I believe it was very, I mean, the panel or tribunal in that case made the same mistake that the appellate body of doing judicial activism by saying some things that they addressing a claim that was not supposed to, addressing an interpretation that they should not be addressing. So it was just the first case. So I think that is the first thing you have to address, the compulsory jurisdiction. No,
I actually. Finding alternative solutions. And I remember the American delegate mentioning, if you want to create a League of Nations, please go ahead. As you know, the League of Nations went ahead without the United States, and you saw what came of it. So I agree that the US will never accept compulsory jurisdiction. I was thinking of a system maybe like the International Court of Justice, where some members accept compulsory jurisdictions while others have an opt-in approach. So there are ways of addressing it, but I think what we need to do is certainly avoid isolating the US in the system. The MPIA is always called an interim arrangement because it doesn't have the intention of becoming a permanent substitute. It has not been very successful because the only case until now was EU Colombia, and it wasn't. Yeah. But I did for Turkey, I think the only ad hoc appeal on the basis of Article 25 of the DSU was Turkey EU on pharma products, where we basically did an ad hoc appeal procedure, which was based to a large extent on the rules of procedure of the appellate body. And the Americans joined as third parties and were actually very, very cooperative during the process. Now we gave, obviously, in order to achieve some buy-in from the Americans, we agreed to respect the time, the deadlines of the appellate body, so the 60 days, and the 90 days. And we agreed also not to rely on Article 11 for the facts. So that was trying to bring the Americans on board, and I think they were quite. So there are ways of doing it. There are ways of doing it, but I fully agree that mandatory jurisdiction is unacceptable for the US. And if we don't extend it to the US, then I don't see how we can force other countries to accept it. So there we must probably go to a mixed agreement.
Thank you. Now, well, let's move on to less contentious topic, to this multilateral initiative that is taking place in the context of the WTO, which is called the Investment Facilitation for Development. This initiative was launched in 2017 and has the objective of establishing a multilateral agreement on investment facilitation for development that will improve the investment and business climate and make it easier for investors to conduct the day-to-day business and expand their operation. This initiative is a proposal for a group of developing and least developed countries, and it makes clear that it does not cover market access, investment protection, and ISDS. So with this brief introduction, I would like to ask Philippe to give us a little bit of background of this initiative and its current status. And also, I would like to ask him what will be the value added to the investment law if this agreement is concluded. For example, is it necessary or desirable to have a legal instrument that focuses only on facilitated investment with soft law provisions such as cooperation, information sharing, exchange of best practices in investment?
And I will use this occasion to demonstrate my earlier point that trade law can be very boring and very technical. Trade and investment, I mean, that has always been, how to say, has been two subjects where people have always dreamt of combining them under one roof. And we saw that in the Singapore issues, the so-called 4 Singapore issues. One of them was trade and competition. The other one was trade and investment. I think we had also the trade facilitation arrangement, and the fourth one escapes me. But except for the trade facilitation agreement, all of them have disappeared really as a subject of discussion in the WTO. So even though in 1994, there was still a clear intention to have the WTO deal with substantive rules on investment, this has completely disappeared from the debate. And I think that more generally, the idea that we should avoid fragmentation of international economic law between trade law and investment law and try to achieve coherence between the two, I think that this has disappeared. This also has disappeared. It's no longer really an issue, and people accept that we should actually move maybe in parallel roads, but we don't necessarily need to converge to the same system. So there may be several reasons for that. Obviously, you may think that it's because the success of ISDS that there is no longer any need for a further regulation at the level or multilateral basis. But again, that the main reason why I think that investment has disappeared from the debate in the WTO is the complete failure of the WTO legislative system. If you want to adopt new rules in the WTO, you need to do it by unanimity, or in some cases you may have consensus rules, but basically you need the buy-in of the 165 members. How are you going to have rules on investment protection or substantive rules on investment being accepted by India, for instance? So there is clearly a realization, and that came certainly also as a result of the increasing impact of NGOs and other non-state organizations on the debate in the WTO. Refer to 1999, the Battle of Seattle, where basically I think the WTO membership realized that making a general agreement on investment and investment protection was impossible. What have we seen? And that is not only on investment. They have many other issues like liberalization of services. You have many other topics where it's impossible to update the existing rules of the WTO. So what has come in its place? We have seen so-called plurilaterals. Now we call them joint statement initiatives, GSIs, whereby actually that you form a coalition of the willing. And you form a coalition of the willing to negotiate certain WTO plus rules, which may or may not be multilateralized at the end. So the investment facilitation for development is such a joint statement initiative, whereby the WTO members, which are willing, negotiate a number of very limited rules, actually. And also the agreement has a very strong development component, because if you want to get something done in the WTO nowadays, obviously, you need to make it attractive for developing countries to participate. And that can consist of the famous special and differentiated treatment, the famous SND treatment, but more and more also you need to pay. For instance, the trade facilitation agreement, and I think that Edna here knows much more about that than I do. There is a fund to pay the developing countries, or to help financially developing countries to implement these rules. So on the basis of what happened with the trade facilitation agreement, we have seen that this investment facilitation for development agreement has advanced in WTO norms, really at the speed of light. Sorry, it's been very, very fast, and we actually expect that it will be officially adopted in the second half of this year. Why is it successful? Because on the substance, it's rather weak, and to a large extent, it's non-binding. Also, it excludes les sujets qui fâchent. So it excludes the difficult issues like investor-state dispute settlement. It excludes investment protection. It excludes market access. It excludes government procurement. And it also has a kind of firewall clause, which basically is aimed at preventing that the provisions of this investment facilitation for development agreement could be invoked in investor-state dispute settlements as being non-respect of these provisions, could be a violation of the fair and equitable treatment or national treatment provisions. So there is this kind of firewall also to exclude this agreement from have a spillover effect on ISDS. So what does it contain then? We have a number of provisions basically aimed at transparency, basically aimed at facilitating administrative procedures, contact points, public digital availability of laws and regulations, speeding up of procedures. So it's basically very much procedurally based, administrative, facilitating administrative procedures by increasing transparency and accessibility of regulations and authorities. Interesting, however, there are a number of substantive provisions also included, but these are not binding. So there are a number of non-binding provisions which are basically aimed at encouraging countries requesting from investors that they adopt a responsible business conduct, RBC. Responsible business conduct, and I sorry that I have to take a look at my notes here. So is the responsible business conduct requires that investors agree to respect international principles, standards, and guidelines that are supported or endorsed by the host state. This was a big issue of discussion because typically the idea is that investment comes from more developed, richer countries towards a number of developing countries. So the requirement that you respect the responsible business conduct guidelines of the host state is obviously weaker in most cases than if it would have been from the home state of the investors. But that debate was closed, so it was the host state. There is also a requirement that members should encourage investors to engage more closely with traditional communities, indigenous peoples and local communities. A third provision recognizes the importance of implementing due diligence in the supply chain. And there is an obligation here, a commitment that requires members to exchange information and best practices in applying these rules. But the first three rules, so the guidelines, adoption of guidelines and respect of guidelines, the engagement with traditional communities and local communities, as well as the supply chain due diligence, remains an exhortation. It's not mandatory for investors, and it's unclear how that would actually operate in practice. Would that be in the form of a contract with the investor, or how it would work? There is also in the agreement requirement on states, on participants to the agreement, to adopt measures against corruption. So the host states are required, but in accordance with their legal systems and internationally agreed standards and commitments, so in accordance with their legal systems, to implement measures that prevent and fight corruption, as long as it falls within the scope of the investment facilitation rules. And then, but that is unclear, and I'm not sure whether it will eventually have been included. There was also a requirement to include provisions on money laundering. So this is the substantive provisions are obviously interesting, but I doubt really, if you ask what will be the impact, whether this will have an impact which goes beyond what is already mostly included in our current most modern investment chapters and fair trade agreements or in bilateral investment treaties. Now, it is expected that the negotiations now, as I said, will be concluded in probably July or maybe September this year. How it will then play out afterwards, because there are 110 member states of the WTO who are participating, but with a notable absence of the United States and India. So we will have to see how this kind of commitments will actually be integrated in the wider WTO framework. Because obviously, if we multilateralize simply the obligations, we give a big present to the US and India without there being any reciprocity. So it's still to be seen whether how this will actually be multilateralized or not. But I think the more important issue that I think it will help on transparency, it will help on administrative facilitating administrative procedures for investment, but it will not have a big impact on substantive rules, or certainly not on dispute settlement. Thank you.
Thank you, Philippe. Following up on this issue, I would like to ask Carlos, if in your view, do you think this initiative benefits WTO members that already have concluded FTAs with investment chapters or bilateral trade agreements?
I think Philippe already addressed part of that question as to how much it will contribute to what we already have in force. The OECD has a lot of these disciplines already embedded they have been discussing this longer than I guess they have been discussing it in the WTO. And it shows also some sort of weakness, I would say, in the WTO. Like Philippe was saying, it is World Trade Organization. So everything has to be looked under the glasses of trade, and investment has to be looked as a trade in its trade aspects, not as an investment discipline in itself. So although they have the TRIMS agreement and there is the GATS agreement, there are other references to foreign direct investment. I think the biggest connection between the WTO and foreign direct investment is that if you have more free trade, you will have more foreign direct investment, because those that are entering those markets can import and export the products that they will be bringing into or producing in those countries. Maybe this is a very maquila perspective of what is investment, but it is a big part of what investment is about as well, particularly for developing countries. I mean, just the nearshoring is really mostly focused only on that type of investment. So I think that it's an effort of the WTO to grab the low-hanging fruit. And that means agreeing to something that is not complicated, that everybody could agree to, because we already have that in other treaties. And it serves the purpose of saying, well, at least there were some least developed countries that didn't have these best practices, and now they will have those best practices, and it will be easier for foreign investors to go and say, what about investing in South Africa, where there were not clear rules before assuming these compromises. So I think that is something positive in itself. I don't think it's something that cannot be achieved. But like Philippe already said, I think it will have little or probably no bearing on dispute settlement other than the corruption issue. Because corruption is obviously a defense mechanism for many states, saying this investment was acquired under corrupt circumstances, under circumstances of corruption. And also these US, but maybe the US regulations and the developed countries regulations against corruptions do the trick already by saying, if you go and invest and do corruption, I can sanction you as well. So it's not only about you going and filing a dispute, but it's what happens to you in our territories and how we can apply that extraterritoriality of fighting corruption. But to that extent said, I think this is something that this agreement may have some contribution, at least that's what I think, into the dispute settlement mechanism, because there will be probably less corruption acts and probably better competition for attracting foreign investment into developing countries. And yeah, that's it.
Thank you. Thank you. Ricardo, any thoughts on this?
That agreement, I would totally agree with Philippe at the end. Is the WTO trying to find relevancy when it has truly become irrelevant? So, and you can even the substantive agreements like the fisheries has a lot of loopholes, has a lot of pending issues. The fact that in the last ministerial, the countries agreed to have dispute settlement until 2024 is really a disaster. And it really shows the lack of trying to find consensus within the organization, even to have an operational dispute settlement system. So to me, I mean, it's a nice effort, but at the end, my problem has been whether this piecemeal approach, which used to work in the past, which is try to get agreements over small agreements, try to become bigger, should be the way to go when you are dealing with a world that needs new disciplines, that needs a revised version of a 1995 agreement on every level. And if you're going, you cannot even agree on a subsidies, on fisheries agreement, full-fledged subsidies on fisheries. I don't know what you can agree on. And talking about investment or investment disciplines, and it is losing a key opportunity, really the forum to discuss issues on environment, issues on the end. I don't think that's going to happen in the short future.
I just have a quick comment that what you just mentioned, Ricardo. I think that it is amazing to me, and I guess please correct me and please let me know if there is any exercise happening today on trying to agree to a multilateral agreement on investment without the dispute settlement. I mean, could that be possible? Could that, because there's thousands of bilateral investment treaties, there's hundreds of free trade agreements, and all of them have national treatment, most favored nation. I mean, many of the standards are shared by all these agreements with little tweaks. And that's a problem of the system that everybody interprets or carves out, but in general terms, we all have those obligations with each other. I mean, the CPTPP is already 10, or I don't know how many members now have subscribed to it. But 10 countries agreed to those standards already. And I guess they are very similar to what they have with many other countries in other agreements. So it will be interesting to, and I think that's where it should be heading to, but I don't know who's going to support that idea of having at least the obligations for everybody saying, can we agree go all to national treatment on investment? Can we all agree to next and do the checklist one by one? And then say, if you want to bring now dispute settlement into some of these obligations, that's up to you. But at least there's a single framework. And then you can think about an appellate body like the WTO that will be resolving on a similar legal framework rather than a plethora of investment dispositions or abroad. Thank you.
We still have a couple of minutes. I don't know if anyone from the public would like to make a question before wrap up our session.
Which kind of rules will govern globalization? And we obviously have the model of at the moment, the multinational rule-based trading system or an investment system, which is under attack. I think what would be the alternative is obviously it could be a purely power-based geopolitical approach to globalization. So there is clearly a danger of politics and geopolitics taking over the multilateral rule-based, the globalization of trade and investment. Whether politics is important, obviously. I mean, I think one of the problems probably in the appellate body of the WTO was the lack of politics in a certain sense, or the lack of pragmatism. And so that I think we have to make a political analysis clearly before going forward with creating an alternative system to what we have now. And I fully agree that the system we had in the 90s is not longer fit for purpose at this moment.
Thank you, Philip. I think our time is up. So I would like to thank all of you for your participation in this session, for your insightful comments. Our next session is on the use of modern technology after a quick break. So stay here and join us.
Yeah. That would have been